I'm shooting indoors today, but some of you may remember the video I did recently in the collapsing church, and that raised an interesting question in the comments. Had that church collapsed on me, would the nice chap who told me to to warn me and tell me to get out of there, could I have sued him? The short answer is probably not, but let me explain why. And I'll explain about something called the Occupiers Liability Acts, because there are two of them. There's the 1957 Act and the 1984 Act. And this is quite useful stuff, actually, because this is something that affects potentially anybody who has control of premises. So first, just a bit of basic background. When you sue somebody for injuring you, or indeed just damaging your property you have with you, um, first of all you have to establish that they owe you a duty of care, and then that they breached that duty of care, and that's what caused the damage. But a duty of care can arise. It can arise contractually. Say, for instance, you employ somebody or you pay somebody to go on a tour. They're a tour guide. Um, there's either an express or implied contractual term that they'll take care of you and look after you. So that's a contractual duty of care. But we also have a common law duty of care to people. And we owe that duty to anybody who can reasonably be seen to be affected by our voluntary actions. Classic example, when you're driving, your duty of care to every other road user, whether it's other motorists or pedestrians, horse riders, people like that. So at common law, you are deemed to owe a duty of care to people visiting your property or premises. But there were actually different levels of care depending on who was visiting. So tradespeople, you didn't owe them as high a duty of care as you sort of did to invited guests, and trespassers, obviously they were treated differently. So the 1957 Act, Occupiers Liability Act, that tried to sort of rationalise the entire system. And now generally you owe the same duty of care to anybody who visits or comes onto your property, although as always, it's the devil's in the detail. So the exceptions are children and people coming onto your property as part of their calling. With children, it's accepted that you owe them sort of a slightly higher duty of care because obviously, children might not be able to read notices. Children sort of, just dafter generally. There's an interesting one. Remember an old series called Mary, Mungo and Midge? I always wondered why that had never been shown again. So I tracked down the series. And the first episode basically is Mungo and Midge breaking into a building site, and by balancing on Mungo's nose, Midge is able to operate the digger and swing it around. And they have great fun, and it just goes to show what fun you can have kids breaking into building sites. So I can see why they haven't shown that since. But also with the other category, which is people, occupying a calling. What that means is that's like people, say you invite somebody to come and fix your roof or to do some plumbing or, an electrician. It's deemed that they would be more aware of those sorts of risks, because it's inherent in their job, but also because they're professionals. They know more about the risks than you do. I mean, you've called an electrician in to make your electric safe, so the duty just shifts back a little bit onto them. Of course, if they stand in your bear trap while they're visiting, that would fall out the exception because, arguably then they're not, that's not to do with their trade or calling. But other than that, you owe everybody else a sort of general duty to take reasonable care. Putting up warning signs, that can assist in showing that you haven't actually breached the duty of care, but it's not an automatic get out. I mean, if there is a sort of very, very serious danger, then warning signs might not be enough. You might have to take some efforts to actually physically prevent people being harmed, like sort of putting fences up or something like that. And again, if it's a site that might be more attractive to children, the level of security you need varies depending on who might want to come onto your property. Conversely, if a danger is really obvious and apparent, then you don't necessarily need to put up signs. One thing to remember when you put up signs, you can exclude liability, enter at your own risk, but you can never exclude liability for death or personal injury. You can, however, say things like, we're not responsible for, any of your property. If somebody parks, you see that commonly in car parks. If you park your car here, we're not responsible for, any damage that might occur. And similarly, you can do that sort of, in your own property. But you can never ever. That's just a general thing. That you can never ever exclude liability for death or personal injury. I mean, that applies in every context. You're not liable for damage that's caused by independent contractors or the actions thereof. So, say for instance, somebody comes in and your kitchen extension collapses on them. It's actually the builder of the kitchen extension that is liable, not you. So, who is an occupier? It's not necessarily the person who owns the land. It's the person, generally speaking, who is best in a position to mitigate against danger and make things safe. So that could be a tenant, but it could just be a common one is, say, for example, you're having some work done on premises and building contractors come in. Then for the time that they are actually doing all the building work, they might be the occupier, and they will put all the fencing up and all the appropriate warnings and sort of secure the site. You can, if, for instance, you do have somebody using your land under a contract, like builders, you can actually put in the contract that for the purposes of the Acts, they are to be regarded as the occupiers. And that could be like, even if you just let somebody, use your land as a car park or something. Although the mere fact that you've agreed that between yourselves isn't necessarily determinative. The court could say, well, actually, I don't care what the contract says. As a matter of fact, this particular party was the occupier. But it certainly goes a long way to sort of pointing out to the courts, if necessary, who was in control. You can also do indemnities between yourselves. So you can say to somebody, well, I think you are the occupier, but if it turns out the courts decide, actually, I'm still the occupier and I'm liable, I want an indemnity from you for any, monies that I have to pay out. It used to be that landlords could actually pass on the liability to their tenants because obviously their tenants are the occupiers. However, the Act makes landlords responsible for things that they should take care of as part of their obligations under sort of, the lease. So if the landlord is responsible for, repairing the building and maintaining the building, then actually the landlord will be regarded as the occupier, even if they've sort of never visited the building. You can actually be an occupier if you've never actually been to the property yourself. Like I said, the test is who effectively controls the property, not who owns it. Now, what about trespassers? It used to be that we have this concept called ex turpi causa, which means you cannot profit from your own wrongdoing. So that would prohibit trespassers for suing. There's also things called non-fit injuria. You can't sue for a risk you voluntarily take on. Again, that's changed now because you can't exclude the death or personal injury elements. But yeah, now the 1984 Act says actually you also owe a duty of care, a duty of common humanity, even to trespassers. However, it only applies actually to death or personal injury, unlike under the 1957 Act, where people are lawful visitors and you're responsible also for their property. You're not responsible for the property of trespassers. Again, though, you can put up notices, you can put up warnings, and there's a sort of balancing act as to how secure you have to be. I mean, ironically, the 84 Act came in on the back of some railway trespassing cases where people had been injured. But there was a case where two kids were going, train surfing and, standing on the roofs of trains, and they'd broken in to the railway yard to get onto the trains. And the argument was, well, the fence was not secure enough. And they said, well, no, this fence was secure enough to keep out sort of, children, who might casually wander in, be injured. But the fact that it wouldn't keep out sort of a determined trespasser who'd actually come, with bolt cutters, they said, no, sorry. And even though the injuries were absolutely horrendous, but as courts quite often say sympathy does not create jurisdiction. But yeah, under the 1984 Act, you do actually owe duty to trespassers. But it's only a duty of sort of reasonable safety. You don't have to make, say, your own house absolutely perfect because you live there. But if you're running a supermarket or somewhere where people are sort of coming in all the time, then yeah, you've got to be you've got to make sure there's no slip hazard. So you might not have to wipe up a spillage in your own kitchen, but you're doing a supermarket aisle. There's also a rather strange thing about the liability for business premises, depending on whether they're, people are attending in the course of business. This is quite highly technical. But say, for instance, if you visited a farm, on farm business, then you were owed a duty of care. But on any other business, you weren't. That's all changed now, actually, because people might attend for all sorts of reasons, especially educational. So, say for instance, a school party goes to a business, whether it's a farm or a factory or something like that. The box factory in The Simpsons. Then actually now, just to sort of not to discourage people from doing that because of the risk, there is a sort of general actually. It doesn't really matter why you attend the business premises now. The law still treats everything the same. But like I say, that's perhaps one of the more obscure technical side of things. And to be honest, if you're in a business where you need to know that sort of law, you probably already know it. So there you go. I think that pretty much covers everything. And yeah, that's why, had that church collapsed on me. I mean, I think it'd be quite rude to sue in those circumstances anyway, but I think the fact that there were big notices everywhere and a massive fence, I think it'd be very hard to argue that that wasn't enough. And and I was certainly on notice of the danger. I mean, that was another thing. Putting notices up, it still counts even if people don't read them. Standard contractual stuff, so long as they are prominent enough to be read. But anyway, as always, hope you found that vaguely interesting. Like I say, I am currently sort of touting for likes and subscribes and things like that, because if I can get above 10k, apparently the codecs work better and things like that. So that's apparently easier for me because things upload faster, and apparently you'll have a better experience, and that's what we want. But other than that, like I say, you're under no obligation to. I'm just happy that people find these useful. And as always, thanks for the comments, because it was a comment that actually inspired this video.